Okay. Very good. Welcome, one and all. Thank you for being here at our convention. Thank you for your interest in this panel in particular. I wanted to take just a minute. We usually have our practice group people who are in charge of putting together the breakout sessions introduce their respective practice group panels. This is a special session of the In-House Counsel Network. So I wanted to introduce it and just say a few words about the In-House Counsel Network so you know what it is. And let you know that we are still open to new members of the In-House Counsel Network. Doing a quick inventory of what was happening in the business world 2 or 3 years ago, we thought it would be good to organize Federalist Society members and Federalist Society sympathizers who are working in-house, whether they're the GCs or principal deputies. That's the idea behind the In-House Counsel Network. We looked at our database, which has tens of thousands of people, and about 120 or so had identified as working in-house. And that's what we started with. We started small, we started sort of quietly, and then when we felt like we had our legs under us and had an idea about what we wanted to do and emphasize, we had a launch conference in Chicago last May, so 18 months ago. And since then, we've had conferences every 6 months and a panel at each of the last, counting this convention, each of the last 3 conventions to highlight the issues that are working in-house. Turns out there are a lot now. There are 500 people involved who are working in-house. So there's a lot of interest and a lot of possibilities. If you know somebody who's working in-house, who's not yet part of the network, feel free to send them our way. With that, I'm very happy to introduce the moderator of this in-house counsel panel, Judge Tymkovich from Denver, Colorado. Judge Tymkovich was nominated to the 10th Circuit of Court of Appeals by President George W. Bush and confirmed in April 2003. So he's been on the bench 20 years now. Congratulations. He served in a variety of capacities since then. Interestingly, since 2008, I consider this giving back in an additional way, in addition to your service to your country, to the academic community and the legal community. He served as an adjunct professor of law at the University of Colorado School of Law. I can go on, but I've told all our moderators to be brief in introducing their panelists, so I will be brief in introducing Judge Tymkovich. With that, Judge, the floor is yours. Oh, can I say one more thing? I apologize. Union Station. I just had a conversation with somebody in the hallway, which concluded with him saying to me, "I'll see you tonight at Union Station." And, okay, you guys get the joke. Good. Don't go to Union Station. Go to the Washington Hilton up on Connecticut Avenue. Thank you. Now, Judge Tymkovich, thank you.
Remember, Union Station. Thank you, Dean, for that kind introduction and for putting this all-star panel together and allowing me to moderate the discussion. I've been coming to these Federalist Society events, believe it or not, since 1982, when the Federalist Society hosted its first lawyers meeting at Yale University Law School. So it's great to have a chance to participate in the society over almost 4 decades. The society since that first meeting has become a national forum for debate on the great issues of law and society, and this panel is no exception. On June 23rd, the Supreme Court issued its 6-3 decision in Students for Fair Admission versus Harvard and North Carolina. The decision took on race-based admissions to private and public universities, closing the circle from Bakke to Grutter to today. While it directed the schools of higher education, the decision was grounded in the 14th Amendment's Equal Protection Clause, but its legal reasoning resonates beyond its factual setting. How will it apply to different settings, like private businesses and state and federal government entities? Many entities have developed and implemented diversity, equity, and inclusion initiatives that set the terms of hiring, promotion, retention, compensation, termination, and possibly more. In a statement shortly after SFFA, the chair of the Equal Employment Opportunity Commission wrote that, quote, "It remains lawful for employers to implement diversity, equity, inclusion, and accessibility programs that seek to ensure workers of all backgrounds are afforded equal opportunity in the workplace. But others saw the decision as much more sweeping. One commentator noted that Justice Gorsuch's concurring opinion made it crystal clear that in his view, the court's rule that an education institution may never discriminate based on race now applies with equal force to employers. Other lawyers argue that it's too soon to know how the current court would answer such questions. Nevertheless, lower courts are on the march. Activist groups and litigators around the country are targeting DEI initiatives on a variety of theories, essentially arguing they promote race-based decision-making or even create hostile work environments. Many entities, from Starbucks to state agencies to venture capital funds to corporate board selections to law firms to airline companies, have been sued over their DEI programs. Now the courts and lawyers must navigate the new legal landscape as they seek to apply the holding of SFFA. Today's panelists are well suited to educate us on the issues and challenges businesses will face going forward. So let me introduce today's panelists in the order of their initial statements. First to speak will be Patrick Strawbridge, who's a partner at Consovoy McCarthy and represented Students for Fair Admission in its suit against the University of North Carolina. Patrick has represented a broad range of individuals and institutional clients on matters of con law, financial and securities regulation, environmental laws, complex commercial disputes, and consumer protection statutes. Prior to joining his firm, Patrick was a law clerk for Justice Clarence Thomas. Next up will be Erin Murphy sitting next to me. She is one of the most widely recognized and one of the nation's leading Supreme Court and appellate advocates. She's a partner at Clement and Murphy and has argued dozens of cases in appellate and trial courts throughout the country, including the Supreme Court and nearly all federal courts of appeals. Does that include the 10th Circuit?
That's the only one I haven't.
Okay, well, you're welcome.
You're really missing something.
Erin clerked for Chief Justice John Roberts on the Supreme Court also. And our third speaker is Seth Waxman, who's co-chair of WilmerHale's appellate and Supreme Court litigation practice. Seth argued in defense of Harvard's admission practice in SFFA and has served on Harvard's legal team since the suit was first filed. The suit was first filed in 2014. Although he did not clerk on the Supreme Court, he is one of the country's premier Supreme Court and appellate advocates, having served as the 41st Solicitor General of the United States from 1997 to 2001 and participated in at least 80 Supreme Court appellate arguments in those capacities. Welcome, panel, and thank you for joining us today. Okay, we're going to start with some opening statements, and then there might be some rebuttal. We're going to have a conversation on these issues throughout the afternoon, and we will take questions from the audience sometime around 1 or 1:05 for those keeping track. With that, let's get started.
I want to make it very clear that the goal of this panel is not for it to go on nearly as long as the SFFA arguments themselves went on.
Yeah, we'll need a bathroom break.
That would have been really nice.
I could feel your pain.
The old chief's method would have moved much faster.
There was a point at which the clerk came out and told all the advocates, the Chief Justice just wants everyone to know that there will be a 10-minute break in between the two arguments, which seemed fine, except that 2.5 hours went by and we were still in the first argument. And I was sitting at the backup table waiting to argue the Harvard case with the current Solicitor General. And I leaned over to her and said, "You probably don't have this problem, but I am 71 years old. And I had at least 8 cups of coffee this morning. And I am no longer able to concentrate on anything that's going on here." When they finally did break, something happened in the Supreme Court I have never seen, which is the jam-packed Supreme Court. Immediately, every single person jolted up and went running out the closest door. And there was a 15-minute break, at the end of which the only people back in the courtroom were the justices and the arguing lawyers. The entire public was left standing in line at the one men's room and one ladies' room available. But we're not going to do that.
Thankfully. Thank you very much for the invitation and for the introduction, and I appreciate all the panelists up here appearing beside us. This is always a very useful forum, and I always enjoy coming here to watch, and I'm happy to be able to participate this year, and I appreciate that. I also have one other piece of, it's not a disclaimer, I have another comment I'm morally obligated to make every time we talk about these cases. And that is that these cases were really the brainchild and the driving force behind them was my dear departed friend and law partner, Will Consovoy. Will deserves all of the credit for the victory that our client was able to achieve in this case. I always go to these functions and I ask people just very briefly with a show of hands, how many of you were lucky enough to have the opportunity to interact with Will Consovoy at some point? Some of you I know have seen him argue in front of you before. I would encourage everybody who raised their hand and who knew Will to go on and try to dedicate yourself to serve with the same commitment and humanity that Will did. It's a model that I try to observe, and I just have to say that when we talk about these cases. So the topic of this panel is, what does SFFA portend, or what does it say about the future of DEI policies in the workplace? And we can have lots of debates about what constitutes a DEI policy, and there's very much an eye of the beholder question that could be asked as to, is this practice DEI? Well, it could be described as DEI, and maybe that's fine. Is this practice DEI? Well, it is described as DEI, and it's emphatically not fine. I will start this discussion with the proposition that as a matter of law, I don't think SFFA really should have changed that much about DEI practices in the workplace. And what I mean to say by that is I do not think that racial considerations in hiring, providing benefits, training people, or promoting them were proper before SFFA was issued, and obviously I don't think that they're proper now. The SFFA was obviously an attack on what we would consider a loophole in the Supreme Court's approach to strict scrutiny in racial classifications. It was a loophole that was very specific to higher education. And I don't think that loophole ever should have been viewed as supporting or expanding what was permissible, either in a state or municipal government workplace or in a private workplace under Title VII. And Grutter itself obviously emphasizes that. If you go back and read Grutter, and you could even go back and read the concurring opinion in Bakke, or the controlling opinion in Bakke, however you want to view Justice Powell's opinion, it also was very clear that it was talking about the higher educational context. That is the context in which both those cases arose, and there's limiting language all over the opinion that says it's limited to the unique context of higher education. And of course, we knew, thanks to the Supreme Court's decision in the 2000s in Parents Involved, that whatever the value of the diversity rationale was in Grutter and in the higher educational context, the Supreme Court was unwilling to expand it even to K through 12 education. And so if it doesn't even hold up through K through 12 education, I don't know whatever basis there would have been to presume that some sort of racial preference regime could survive outside of the educational context entirely in the workplace. And I think that there were other clear warnings of this fact as well, indeed some that long predated Grutter. Adirond construction is a very good example of where I think the court drew a fairly clear line that a non-remedial program for federal contractors could not deploy racial classifications. There was a similar case involving broadcast media licensing. There was the Ricci case in 2009 that I think made it very clear that fear of liability could not justify racial classifications in public hiring. And even as recently as the Bostock case, the court was very clear in interpreting the language of Title VII that says, if you are making a decision that is somehow a function of sex, that is permitted by Title VII's clear language. I will leave for other panels, thousands of other panels, past and future, as to the sustainability of the reading of the term sex in there. But obviously Title VII also includes the term race. And so to the extent that Bostock is saying, if you are making decisions based on race, you are violating Title VII, which I think a lot of people read it to say at the time, I think that was as clear a statement of law as anybody needed long before, well, maybe not long before, but several years before the Students for Fair Admissions decision came out. Now, all of that is not to suggest that Students for Fair Admissions decision is somehow irrelevant to employers. The fact that there were, a number of warning lights popping up on your dashboard every time you got into your car, for 5 trips before, doesn't mean on the 6th trip now you should ignore the warning lights. And SFFA, I think, makes very clear that to the extent that there was a desire to employ racial classifications in promoting or training or hiring, or even in employee compensation or in benefits provisions, it obviously undercuts the suggestion that there can be some sort of abstract goal of racial justice that doesn't have any individualized harm. It obviously talks about the importance of ending racial discrimination, and it meaning we end all racial discrimination. So to that extent, I think SFFA is just simply another in a long line of cases that says strict scrutiny applies. If you're not doing direct remediation for immediate past discrimination, you're almost certainly going to fail to uphold a racial classification. So that is my opening remark.
Thank you. Erin?
Thank you, Judge, and thanks to FedSoc for inviting me here today, and all of you for joining us on what is certainly, I think one of the more pressing questions that a lot, as the opening remarks indicated, that everybody in pretty much any area is confronting, no matter what kind of company or business or public, private you have. There's a lot of questions right now, and I think that's partly because while pretty much everything Patrick just said about where the law is right, I mean, it's true that the court made very clear that this line of cases was about kind of an exception to the general rule that created kind of a greater toleration of the use of race in the higher education context. As a practical matter, I think there's a bit of a public perception that it's almost the opposite right now. We are at a moment where we have the Supreme Court putting out an opinion in this area at the same time that DEI initiatives are probably at their height, at kind of the highest level they've been in quite some time, which creates kind of a bit of a dichotomy from the perspective of, the way I think a lot of the public is thinking about this issue, the way companies are thinking about this issue, the way boards might be thinking about this issue, people who aren't lawyers that aren't kind of focused on it through that lens. It's almost like the diversity concept that was built around these cases in the higher education context became the blueprint for thinking about, how do we extend all of that into the context of private companies and employment and all of these other areas. And Patrick's right, that is certainly not what the court was ever saying it was doing. And by and large, the court has said, no, in that context, you're not supposed to be taking race into account. Now, I think a lot of where the rubber is going to meet the road is, the Supreme Court has a line of cases that says, yes, companies can have voluntary affirmative action programs. And there's a lot of debate about what exactly that means. Certainly you can read those cases to allow for kind of a relatively loose conception of what it means to have a remedial program and what it means to have something that is designed to advance the interests of your particular business. I'm not sure that's the way a majority of this current Supreme Court would read those cases, and I think they may be more inclined to say, look, the only exception we were ever trying to recognize in the context of Title VII is for true remediation, in the sense of if you yourself as a company has engaged in some sort of past discriminatory practice, certainly you can remediate that. But if you're talking about kind of taking a broader approach to remediating what are viewed as kind of the broader discrimination that's occurred in society and history, I think that's something that's going to be really hard to get this court to think is the right way to understand Title VII, or the right way to understand even its cases that have allowed a little bit more room in the Title VII context. And certainly we know a couple of justices have already made very clear that they don't see it that way. And Justice Gorsuch lays out a pretty compelling argument that if you take Bostock seriously, it's hard to reconcile that with the use of race in employment context. But I think the other really critical question in all of this is, I mean, obviously, a lot of employers are private organizations. A lot of companies are private organizations that are not bound by the Equal Protection Clause. And so some of the important questions are, what is the reach of the federal statutes that are the statutes that operate here? Because, you know, there's a lot of law about Title VII, but certainly not every aspect of DEI initiatives is driven, it has to do with actual employment decisions. There are initiatives that companies have engaged in that involve things like just broader grants, you know, kind of just broader community service efforts, charitable giving, all of those types of efforts that are going on in companies that don't fall within the bucket of Title VII. And some of those have been challenged. They're challenged through Section 1981, which raises questions about Section 1981 covers contracting. And, you know, so you have to get into questions about, okay, what does and doesn't count as contracting on the part of a company. So some of these threshold questions, I think, are going to be a lot more important right now. I mean, even in the Title VII context, there's a lot of law about what is and isn't and a decision that's covered by Title VII, but there's open questions there. The Supreme Court's hearing a case in December about whether, you know, about the understanding of what's covered by Title VII. And there's a bit of an interesting dynamic at this point because, you know, generally the EEOC has taken about as broad a position as it can take on what counts as an employment decision covered by Title VII, which creates some interesting dynamics if you end up having a court that makes very clear that that means all of those decisions and all of those actions are actions that are going to be viewed kind of more through an SFFA lens. But so I think a lot of the litigation here to keep an eye on is not just the question of how do these equal protection principles apply through the various statutes that matter here, but also what is the reach of those statutes? And, you know, that, as Patrick said at the outset, DEI is a very large bucket that covers a lot of things. And what it mean, you know, what this case means for straight up decisions about who to hire and fire, et cetera, you know, may be relatively clear, whereas it may be a lot harder when you get to things that are further away from that, things that involve just efforts to broaden the applicant pool, or things that have nothing to do with employment decisions at all and are just basically corporate initiatives driven by corporate giving and such that don't implicate Title VII and get into some trickier questions about a very differently worded statute that has a very different scope. So, you know, I am not, Patrick, I know, is litigating pretty much all of these issues everywhere, so I'm sure he has strong views about the scope of both. But, you know, to me, this, both in the higher education context and more broadly, I think this is really the beginning, not the end, of the conversation with the courts about what is permissible in this area.
Thank you, Erin. Seth?
Well, I want to thank Dean for inviting me here and thank all of you for listening to me. You know, when I heard Judge Tymkovich say that he's been attending the FedSoc convention, well, wasn't a convention then, but FedSoc meetings since 1982, it made me realize that I guess I'm also old enough to say that I also have been pretty much not attending, but speaking at FedSoc meetings. I think without exception since 1982, not because I am a member, I'm not a member of the Federalist Society or the American Constitution Society for that matter, but I feel like these events and similar events that provide an opportunity for our profession to speak amongst itself and to others about interesting questions and differences of opinion is so important. And it seems like it becomes more important every year as the broader American society becomes more tribal and shrill and sort of uncomfortable and unwilling to engage with people who might have different ideas or might come from different perspectives. So I like being here, and I appreciate the annual invitation. I have to say that I'm feeling a little deflated right now because I agree with everything that Erin said, and much more with what Patrick said than we normally find ourselves when we're sitting at council table, in those instances with the podium in the middle. And so, you know, I think a lot of what you're going to hear from me is, and among the panel, is not all that different. I certainly agree with Patrick's opening remark and Erin's concurring remark that, you know, the SFFA versus Harvard and North Carolina cases had nothing to do with Title VII or employment decisions. The things that were legal and illegal under Title VII and whatever the yet undiscerned scope of Section 1981 is, were just as illegal the day before the Supreme Court decided the case than afterwards. I also agree that nonetheless, there are some important clues that private employers can take in terms of how they structure their own employment practices by what the Supreme Court majority opinion did say in the SFFA decision when it sort of near the end of the majority opinion talked about the kinds of things that, of course, even universities can continue to consider and continue to do. And so, you know, I'll say before I'm doing the pre-buttal before I do my sort of opening remarks, but I can't let the opportunity, I can't just drone on with my opening remarks without coming at Patrick with something. I think
That's the point of the panel, I think.
I mean, I think everybody would be disappointed.
Yep, is the kumbaya moment's over?
No. I'm searching for opportunities when we won't be kumbaya, because I know everybody has enjoyed a sumptuous and delicious lunch, and this is the appropriate time of the day when the body's natural rhythms suggest that if something exciting isn't really happening, probably would be better just to close your eyes. So I do disagree. I mean, the fact that the Supreme Court in SFFA, if we're talking about the diversity rationale, has, you know, reversed decades of precedent and now has held that diversity itself, the interest in diversity in the educational environment and perhaps extrapolating beyond, doesn't constitute a sufficient compelling interest to justify the use of race as a decisional factor under strict scrutiny, does not at all mean that diversity considerations are not valid, they're not important, and that private companies are not precluded from prioritizing that if it is consistent with the corporate culture and the values that the corporation, the kind of workplace that the corporation wants to foster. And so I'd like to basically make 2 points. One is, I think that thoughtfully designed corporate diversity, equity, and inclusion programs are not only legally permissible, but from my perspective, I think they're important both for businesses that have those values and for American society more broadly, and that there are within the bounds of what constitutes DEI, and I totally agree with Patrick that it is a vague term that can mean all sorts of things to people, and is not that useful as a concept. It's an expression of goals. It's not an expression of the means by which companies that want to achieve or promote those goals can go about doing it. And I'd like to suggest that there are a lot of kinds of corporate DEI initiatives that are entirely lawful and valid. And I never thought that my practice would come to providing advice to corporations about, you know, something like, you know, their HR departments and what their programs are. And I honestly didn't think about it for 1 millisecond in the 10 years that Patrick and I were litigating the Harvard case. But I do find myself now contacted by lots of company general counsels who are, you know, on the one hand getting threatening letters saying, you know, you're violating the Constitution and you better stop doing X, Y, and Z, or we're going to investigate you or sue you. And on the other hand, letters from other law enforcement people and shareholders and stuff saying, what do you mean you're not doing these programs, you're not doing enough? And it's a genuine question. So let me just make a couple of points. One is with respect to DEI, there is now a very rich and deep body of social science research that shows that properly designed DEI efforts correlate positively with financial performance, but interestingly, so far as I'm aware, that demographic diversity in and of itself doesn't. And so demographic diversity alone can fail to achieve financial benefits without the kind of equity and inclusion measures aimed to ensure that a company's employees all feel supported and that they can thrive at work. I think that the data shows that DEI initiatives can enhance companies' competitive position, their agility, their innovation, and their brand perception. Now, the other thing I would say is that our nation is now remarkably diverse in a way I never could have foreseen when I was growing up back in the Elizabethan times. And yet it is distinctly conscious of race, privilege, other demographic factors and differences. And my own view, and this is my view, is that by training employees on the benefits of principles of diversity and equity and inclusion, and creating programs that ensure that all employees are supported, that corporate America acknowledges these realities, equips their teams to achieve, and can act on their own values. And my second point is that there are many DEI practices that are entirely lawful. As I said, and as Patrick originally outlined, DEI is a vague term that's named for goals, not the measures that are designed to achieve them. And I think entities, including private companies, can aspire to share DEI goals, but develop and adapt measures that are tailored to their own environments and their own goals that are suited to their particular needs and their communities and their contexts. I think an unfortunate side effect of the amorphous nature of the term DEI is that it can be cast as some sort of threatening boogeyman in which nobody is really sure which practices are being discussed. And it's led to a lot of castigation and confusion and championing of practices without a real focus on what is or isn't permissible. And so let me just be clear about what I'm talking about in terms of defending and advocating for thoughtful, lawful DEI practices. It is clear, and I agree with my other panelists, that long before SFFA versus Harvard was decided, and in fact long before it was brought, it was entirely clear that race-based employment decisions, that is, decisions on hiring, payment, job allocation, et cetera, that are based on race qua race, as the Supreme Court calls it, have been illegal under Title VII for decades. There was no Grutter, Bakke, Fisher exception to the ban on using race for its own sake to make employment decisions. On the other hand, there are lots and lots of things that can be done in the context of DEI programs that are entirely permissible, that focus on topics involving race, involving gender, involving other characteristics, and they can be tailored to the likely interests and experiences and needs of people with particular backgrounds, so long as they are available to and open to all employees. And so, for example, let me just tick off, a laundry list of the types of DEI programs that I think, again, tailored to a company's particular interests and needs, are not racially exclusionary and that foster DEI goals. I think Erin mentioned recruiting efforts and casting a wider net. I mean, outreach efforts for employees that cast a wider net and diversify the pipeline of potential candidates, entirely lawful and perhaps laudable. Application materials that underscore, that don't prioritize or in any way suggest that race is a decisional factor, but underscore whatever importance an employer places on principles of DEI so that potential employees understand the environment that they're going to be coming into if they're hired and what will be expected of them, entirely lawful. Mentoring and training programs for employees who have faced some form of adversity in their lives, including, though by no means limited to, those for whom adversity is somehow tied to demography. Programming by companies for employees and officers and directors that are focused on particular topics, including the histories and contributions of members of minority groups. Employee resource and affinity groups that, including for minorities, women, and others, so long as all of these groups are available and open to all, regardless of their identity. And training sessions that bring awareness to unconscious bias, that inform employees of the company's views on the business benefits of diversity in all of its forms, and that instill the corporate values of inclusion, equity, and respect. And I think at least the advice that the frame in which I've been advising corporate employers about this more or less go along those lines. Now, we can argue at the margins about, and I suspect that at least Patrick and I will argue the margins about some, at least I hope so, because I even though I'm as old as the age is, I still hope to be litigating important issues, and Patrick provides a delectable array of outrageous and controversial law opportunities for that. But look, corporations, as Erin said, corporations are not bound by the Equal Protection Clause. They're not bound by the First Amendment. They are, in fact, First Amendment speakers, and they're entitled to speak and make decisions in support of their values, so long as those values so long as that implementation doesn't violate a federal or state statute. I've been thinking, for personal reasons, very deeply for the past 32 days about the Hamas attack on Israelis and the consequent war. And, one of the most immediate reactions was, when a bunch of Harvard students on the second day of the slaughter came out and said that the blame for this is entirely on Israel and the Jewish people. Davis Polk wrote letters to three 3Ls that it had given offers to, saying, the view that you express doesn't in any way reflect the values of our law firm, and we're not going to hire you. We can agree or disagree about whether these individuals should be tarred with those particular statements with they align themselves, but there's no argument that corporations and law firms can't make cultural decisions that support those values.
Yeah. I suppose a lot of it, like most things in life, the devil is in the details. And Patrick, you've been on the front lines of looking at specific examples of how these initiatives are deployed in businesses, I assume public entities and the like. What are you seeing on the front line? Are these mostly educational and high-level training programs, or are they something else?
Well, I think that there's, I think when my friend Mr. Waxman says, there's nothing wrong with having goals. There's nothing wrong with having sort of aspirations. I think actually it is a very fast line from an alleged goal or an aspiration to an intent, and the intent is to achieve a result. And we saw this in discovery. I'm not going to speak specifically to the Harvard case, but in some of our university cases, if you got a witness from one of the DEI offices, one of the many DEI offices on campus, and you got them on the stand and you asked them under oath, do you have, are you using race to achieve a certain outcome in, your department, whether that's students or grad students or professors in hiring or staff? And of course, oh no, we just have these goals, but it's not about the numbers. We just want to make sure we understand how we're doing compared to our community or our society. But it's not a quota. It's not a target. But inevitably, all of the actual underlying analysis boiled down to numbers. There were comparator numbers to all of their fellow institutions. There were reports at the end of the year that said this is how many we had from this group last year, and this is how many we had group this year. And I would submit to you that just, it's a bit of a Mott and Bailey argument. It's like, oh no, these are just aspirations, these are just goals. But if your goal is to achieve, or if the way you are measuring whether you have achieved diversity is by the composition of your workforce, then I think that's at least a pretty strong prima facie argument that you are engaged in unlawful discrimination on whatever category it is that you are so carefully tracking. I think that, I don't think it matters if I don't think the answer to that changes if you argue that it's important to the culture of your institution that you have a particular makeup or a particular constellation of people working in your office. If you are breaking down your workforce by race, and if you are publishing whatever you call them, goals or benchmarks or comparative charts that look at your workforce based on some sort of protected characteristic, then I think that is extremely strong evidence that you are engaged in improper racial discrimination. I don't think that there's anything, I certainly don't think most people would agree that there's nothing wrong with efforts by corporations to ensure that they are providing equality of opportunity. And the difference between equality of opportunity and equality of result is one of the debates in this particular area of law that goes back to when Seth first started speaking at the Federalist Society. It's always been, I think...
And Patrick was in short pants.
That is true. I think that's always been the debate, but my experience in both what I've seen in litigation and generally in the culture is that in the last few years, maybe 5 or 10 years even, those lines have gotten increasingly blurred, and that the current view of many people who operate in this area, and certainly of the activist populations who are antagonizing for greater representation, is that the only thing that matters is the equality of the result, and the only thing that matters is the numbers. And it's not a theoretical thing. I would commend to folks, if you want to do a deep dive into the Harvard record, there was an amicus brief filed by the Hamilton Lincoln Law Institute, and I don't know if Ted Frank's in attendance in here or not, but I always like to give him credit, or give his lawyers credit, that highlighted some very specific examples of corporate compensation being tied to the content or the demographic makeup of the divisions that they were involved in. And there are other examples, public examples out there of racial pricing discounts. If you are offering mentors on a racially exclusive basis to people of the same race, I think that violates the law. And I think, in my experience, there are many people of all races who find a lot of these practices, setting aside their legality, they find them offensive. They find them in some cases infantilizing. They find them in other cases to be based ultimately on stereotypes. If you are making judgments about somebody because of their membership in a particular community, it is very easy and very quick to see how that just boils down to a simple stereotype. You are assuming something about that person's views or experience, or you are assuming something about what they can contribute to the office based on a characteristic that is not causal to whatever outcome you are presuming that they can provide. So Yeah, in my experience, I do think that a lot of the initiatives here are not justifiable, and that doesn't matter whether they're profitable or not to the company, or if the company thinks it's good business sense. I think our history has shown, and a lot of companies, if they were put under oath, might admit that engaging in certain racially discriminatory activities might actually be beneficial to their bottom line, but the law does not tolerate that as an excuse.
Erin, what do you see as the threats to companies when they implement these types of programs? Should inside counsel come to your law firm and have you review the HR materials? If you want a new practice niche. But what would you say?
Look, I think what some of this conversation is reflecting and what we've seen in practice is it's just it's a fine line and a slippery slope. You start out with goals, and there may be nothing wrong with the goals, but we quickly see, and I think some of this goes to that kind of diametrically different perception culturally right now that I was talking about, that leads to results that are quite striking. I mean, it just, as one kind of powerful example, we seem to all three of us be in like violent agreement that it was perfectly clear before SFFA that you could not have a program that excludes people on the basis of race. Yet not just companies, but several large law firms had programs that were doing that. I mean, these are entities that if anyone should know the law about this stuff, it's them. But nevertheless, we got to a point where that was becoming kind of commonplace. And I think that there's a real danger in that, when you sort of start with the goal, and the goal is laudable, and you're looking and thinking, wow, it seems like, we have a problem with diversity, or we have a problem with retention on a diversity basis. Like, there's nothing wrong with that. But you do have to give a lot of thought to, okay, how are we going to address it? If it's, we've realized we have a retention problem, and maybe some of that is because of mentoring, well, that's a reason to kind of think about how do we restructure everything and ensure that we have a good mentoring program that's meaningful for everybody, because some people seem to need more mentorship than others, as opposed to, let's single out the people who we think need mentors and give them something that we're not offering to other employees. I think if you start from that principle of it's always going to be problematic if you're offering something, if you're excluding people from something that you're providing, whether sometimes it can be even at the level of compensation. If you're doing that, you're going to have a real problem. And that, I think, carries through even in things that are kind of softer aspects of the workplace, that if you're providing something, whether it's the special bonus, the special kind of scholarship entry into the workplace, or it's just something that seems softer like mentorship. I mean, if you're making those distinctions on the basis of race and only offering them to certain groups, or on the basis of sex and offering them to certain groups, I think that's where you start to get into trouble. So I do think, given, it's really tough, I think, for companies right now, because I think a lot of these programs are driven by a lot of external pressure, or pressure from, kind of from whoever the investors in the companies are. And we all know from being people who work with companies and work with private equity groups and all of that, there's not always a complete understanding of the law. And people do come at it sometimes from that end of, look, this is what publicly it seems like we need to be doing right now, so let's do it. And I think that's how we ended up in a rather remarkable place over the past 5 years, where we had some companies that were essentially doing like straight up quotas, or, we will not hire you or utilize you if you don't put people of a certain race on the work. I think that all starts to become really, really problematic. And so while it's, all well and good for us to kind of say like DEI on the front end, it's a good and it's a laudable goal, like the devil really is in the details. And frankly, if I were a company right now, I probably would get legal advice pretty routinely on what you're thinking about doing, because I think there's just become such a disconnect culturally in what's permissible as compared to what I think the Supreme Court is telling courts and telling the public is actually permissible, that there's a real risk of kind of crossing that line even unintentionally.
relatedly,
Excuse me for jumping
yeah,
back.
go ahead.
Jumping back in before Seth. I'll be
No,
brief. But
I'd rather follow you.
I did want to address, and this sort of goes to that point, or at least one of the points that both Seth and I think Erin are getting at, and that is that there is equally a relatively developed body of social science that says the implementation of a lot of these DEI programs are actually, especially the ones that focus on race, whether that's trying to address the concept of privilege or anti-racism, are actually a net negative on the workplace, and they're a net negative on workplace relations, and they actually increase dissent and strife among members of the workforce. And I think, of course, that is an important lesson for us all to bear in mind, and it's an important lesson that SFFA at least does reiterate, which is that when you divide these people into categories and you speak about whiteness, it shouldn't be considered any more permissible than speaking about blackness or Asianness or Hispanicness. These are relatively poisonous concepts, and it's not just me saying that. There's social science that suggests that as well. So I think that a suggestion that we should stop focusing on this so much and that we should stop having goals that are organized around these demographic characteristics is a good one.
Seth,
Yep.
what would a company brings in it has a pretty aggressive DEI program that may be along the lines that Patrick's saying, that, may contain contested ideological or political or philosophical concepts, and you have an employee that is offended by these. He thinks that he's being targeted because of his race, hypothesize a white employee, and he objects to the training program. He gets fired and files a claim for retaliation. Is that something that we might see flowing out of these programs, and how can our corporate counsels avoid that type of scenario?
Well, let me answer your question directly, Judge, and then go back and make a few supporting points that, once again, endorse, but with some qualifications, what my fellow panelists are saying. I mean, look, if you're describing a situation in which an employee believes that she or he has been subject to an adverse employment decision or subject to what, the strict standards for what Title VII establishes as a hostile work environment, which is also actionable under federal law. That's what we have courts for. And there are instances in which employers have engaged in that over a long period of time, and courts are available to adjudicate those things. We can all agree, and perhaps we can stop, in the interest of keeping our audience's eyes awake and our own, we can stop talking about whether it is permissible for corporations to use race, or for that matter, gender, or other demographic characteristics as, for their own sake, as decisional points. That is, that isn't allowed. It wasn't allowed. I agree with Erin that there were instances in which, even though it wasn't allowed, it was done. One of the very first companies that contacted me over the summer to come in and do an audit of their program actually had a program in which division vice presidents were told that their compensation, their bonus at year end would turn, among other things, on the number of minorities that they hired over that year. I mean, my reaction to that is, look, there's some things in life that are difficult. There's some things in life that are actually easy. This is easy. That, you can't do that. You couldn't do it. You haven't been sued yet, but you have to stop doing that. And the same is true, and I think, the answer to the question that you gave Erin, which is, should companies, go to Erin for outside counsel, or Erin and other, the answer is yes, because general counselors are subjected to conflicting advice, conflicting pressures. It's always, the easiest thing is always to say, look, we're just not going to do any of this anymore because I can't lose my job if I'm not sued, and if we never do anything, we can't be sued for it. On the other hand, that's not where our society, and it's not where many corporate goals are. I don't think that the line drawing, I haven't found that the line drawing with respect to specific kinds of programs is all that hard. The hardest example is, the example that Erin was giving, and Judge, I think you were questioning about, which is, what about some sort of diversity training program that derides, what the terms I've heard are white privilege. Mm-hmm. I think about, again, in the context of this horrible Hamas attack, this student at, I think it was Stanford University, who the professor basically said, if you're Jewish, you need to stand up and go over there because you are the colonial oppressors. I mean, it's not a work environment, but boy, if that isn't an actionable, hostile environment, I don't know what is. And, no company is going to want to have a program that basically constitutes giving its employees lectures about how worthless they are or undervalued they are or anything like that. That's common sense. And if it happens, the companies are likely to be faced with complaints, well-founded or otherwise, of creating a hostile work environment. That's not at all what I have in mind when I say that thoughtful DEI programs are, not only lawful but important. The other thing I would say, just to harken back to Patrick, lest people get the impression that we're now two peas in a pod, is I think there are limits. There are limits that perhaps Patrick's comments don't recognize to the inferences that can be drawn to attention that's paid to numbers. Quotas, balancing, that kind of stuff can't be done. Couldn't be done in corporate America before, can't be done now. On the other hand, companies are allowed, and in fact required under federal law and the law of most states, to collect, it has to be voluntary, but to collect and report. If you're a government contractor, or you're an employer with over 100 employees, you have got to report on demographic statistics about your employees. Now, we can argue, and Patrick will bring a lawsuit that gets a court to decide whether those kinds of reporting requirements, which have existed since at least the Nixon administration, are or aren't lawful. But the notion that corporations and employers should stop asking potential employees or employees voluntarily to identify their demographic or gender characteristics is completely unrealistic. I think what I've advised employers to do, and what I think employers should do, is to solicit voluntary answers to that, as, for example, the Common Application does for college applicants, but to ensure that that kind of data is not, in any event, is not part of the decisional process in who to hire at what rate. And in fact, the safest thing to do is just not to have that available to the employment decision makers. But the notion that just because these statistics are collected, one can draw an inference that discriminatory intent is involved is overbroad.
I think NASDAQ has a recent rule, requiring certain types of data collection that's up in the Fifth Circuit, I believe. I think California has a statute that encourages or requires certain representation on board of director membership. What's your take on those types of, kind of government action promoting diversity within the workplace?
Well, I think if you're requiring companies to hold particular slots for people of particular races, it's unlawful. And I don't think that's hard. You are right that there are rules, and there is even government statutes that provide for that. No doubt with the view that it's of the best of intentions to increase representation or to ensure a particular viewpoint. But again, I would submit that if we are assuming that putting a certain number of women on your board is therefore going to lead to a particular set of viewpoint exchanges, you are engaged in stereotyping and assumptions about what individuals are going to offer based upon a protected characteristic. I don't disagree with the notion that collection and reporting of voluntary data is required by some regimes, and it isn't even required for appropriate reasons, such as to make sure that we are not discriminating in hiring or selecting in who our employees are or who we might be promoting. But what I would suggest to you, and what I have seen, at least with my own experience with DEI offices, is that this is not a simple exercise in reporting and passing it around once a year. It is a continual focus of interim reports. There is an awful lot of effort spent on comparison with other similar institutions. It is often the subject of individual demands or stated reports that we have to do better on this metric, we must do better on this metric. And I don't think it's very hard when you actually take a holistic view at the documents that are being created here to come away with the very strong impression, if not the conclusion, that this is not just simply an exercise in gathering data to make sure that something's being missed. It's an exercise in harping upon the demographic balance with a goal toward achieving an outcome. That will obviously depend upon what the records are in each case, but it is, I guess I don't have the same experience with Mr. Waxman, at least with what I have generally seen, but in my experience, a lot of the literature and some of the training materials that are out there right now do engage in stereotyping, and they do create a hostile situation for folks of particular races, and it is done under the intention of trying to establish an understanding about privilege or to broaden someone's perspective. But one of the problems, this is always a problem, I suppose, for government and also for corporations, is it's one thing to have a lofty ideal and to think that you can carefully manage the lines of what's permissible and what's not permissible, but somebody at the end of the day gets hired to do this. And at university, it seems like hundreds of people get hired to do this. And in companies, an increasing number of people get hired to do this. And they are out there taking actions. And to presume that once you have told people that there are good ways and bad ways to take into account people's demographic characteristics, you are at the risk of how each of them is going to view where the line can be drawn. And I would suggest that that's a serious liability risk for everybody, and counsels against charging them with the mission of trying to walk that line in the first place.
Erin, what do you see the consequences might be for the affirmative action space? Those cases that, I think you touched on that, but what in this post SFFA environment we have?
Yeah, I think that's really, frankly, going to have to kind of be the next piece of this that gets litigated, because there is this line of Supreme Court cases from going back a while that says you can have a voluntary affirmative action program of some type within a company, and I think that it's been run with a little bit. But if you look back, what the court said is that it has to be kind of temporary, again, hearkening back to what they've now said in kind of the reasons they ended up getting where they got in SFFA. It has to be kind of specific to your company and your company needs, and it has to be based on, it has to be a remedial effort. And I think partly because we have that societal disconnect, I think there's a tendency to think, oh, well, that's pretty easy to accomplish. Like, we have a program, and it's we'll have something that's sort of short term, and it's specific to us, and of course this is about remediation, and we're remediating the problem that we seem to have underrepresentation, or we seem to have a retention problem, or whatever it may be. I don't think that's likely the way the Supreme Court's going to end up thinking about that. I think that if you're really coming at it through a Title VII lens, remediation has to kind of assume essentially you're remediating a Title VII violation, and that you've actually engaged in some sort of impermissible discrimination that you need to fix. And if you're starting from the point of thinking about it as we have a diversity problem that we need to fix because there's underrepresentation of a particular group, or we're having trouble, women seem to leave more quickly, or people of certain demographics are not advancing. That's really coming at it from the wrong lens, because you're assuming, that there's sort of a problem to fix when I don't think that's kind of the type of remediation the court has in mind. It needs to be, okay, well, let's look at that and ask ourselves, is that because we engaged in some sort of intentional discrimination? We had some like Title VII kind of violation somewhere along the line that's causing those results? Or is it just, having to do with lots of other aspects of society, and maybe you kind of take that and you figure out there's things we need to change within our company. There may be things we need to do to work on retention. There may be things we need to do to diversify the workforce application and all that. But if you take that to the step of, no, we're going to have like an outright affirmative action program that draws these kind of distinctions, I just think the space the court is leaving at this point for programs that are drawing distinctions on the basis of race and trying to justify those under kind of a strict scrutiny type regime is probably going to be pretty narrow, at least in the context of employment decisions.
Seth, you probably argued some of those cases. What's your take on that?
I mean, I agree with Erin. Again, I've said it so often in this program that I'm afraid my own eyelids are going to drop if I say it again. But I'm not exactly sure what we're talking about when we're talking about affirmative action, but I agree with Erin that it's subject to the restraints that she's identified. I mean, companies just can't use race or gender as a decisional factor in how they're going to constitute or operate their employment systems. And I agree. I mean, if there's a problem where, we have, members of a particular gender or a particular demographic appear to be leaving and not retaining and stuff, the way that DEI programs address this is to try and figure out why and what we can do without making a race-based distinction to make the workplace more inclusive and make people feel like they're sufficiently valued and supported that they don't leave and that they stay. And those programs are all to the good. Patrick's notion that, there are going to be tough cases and there are some, there's some implicit things going on such that companies really ought to just, there's all of these efforts are fraught and can be abused it's just it's a waving a flag of defeat. I just not consistent with what companies want and what companies should be doing as responsible corporate citizens of our society.
I mean, I guess I would just say, while we all like to think that companies see the line and aren't crossing the line, I mean, it just doesn't seem to be true in practice. And I think, many people here, we have people here who are in corporations, but many of you have worked at big law firms. Now, big law firms, pretty much every big firm is looking at their summer associate class and asking how diverse is it, and comparing it to other big law firms and saying how diverse is our class compared to these other law firms' classes. And the diversity that's reflected in the summer associate classes at the average firm is not, is often not anywhere close to even just if you were kind of thinking about it as we want like strict proportionality to society. Now, it's hard to really look at that and say, but race is not being used as a decisional factor here at all. Like it's just happenstance that all of these big firms are kind of, thinking about it in some loose way, and it's not really impacting their ultimate decisions. To me, it's the same problem in a lot of companies and employment contexts that you have in the universities. Is you think if you don't say it explicitly, then it's not an affirmative action program. But I don't think that's the way these cases are really going to play out under the principles that the court is articulating and applying. And if you take the same principles that it's articulating in the education context and apply them to a lot of the programs and the ways that hiring happens in a lot of companies right now.
I'll just say that now I'm the one who's in agreement with what Erin said, but I'm in agreement with what Erin said.
That's not that surprising.
She's supposed to be the middle ground between us.
We've sort of narrowed the territory of the middle ground, but we can posit that Erin's in the middle.
the attention to these characteristics, no matter how much we like put a disclaimer at the bottom that says, and of course don't use this for decision-making process, is just not, I don't think, consistent with what people's experiences are or what the average person who's sitting in their office who receives these messages and these updates is going to gather. And to me, I guess what has been most remarkable for the last 5 or 6 years on this front, and why I think it suggests that there really is a problem and we really should be cautious about using these categories with our employees, is just how much express, racial contract, set-asides, law firm internships, were explicitly made only open to people of certain demographic groups. We're all standing up here saying, well, of course that was unlawful, and it was unlawful before SFFA, and it's unlawful after SFFA. But the examples are too many for me that I would have believed 10 years ago of municipalities specifically saying this contracting program is open only to members of underrepresented minority groups. And in my experience, what happens is when you are so fortunate as to find somebody who has standing to sue one of these programs, immediately they wave the white flag. They get sophisticated lawyers from great law firms like WilmerHale to come in and tell them, well, no, that was a misunderstanding. That's not how the program's going to work. We've overhauled the criteria. There's nothing more for the court to do here, and so no order is necessary. And if no order issues from the court, then there's no cost or liability to the company other than hiring the firm to come in and change their program, because you cannot get, a fee award, even though it took considerable expense to find a plaintiff and to draw up a complaint and maybe to draw up a PI motion and bring it. And the feeling that you're left with is this is kind of a catch me if you can type rationale, where many people know that they will be able to get away with it because there's only so many Consovoy McCarthys out there on that wall enforcing these rights. And if you don't find a person with standing in a particular jurisdiction, it can basically stay in place unchallenged. And if Consovoy McCarthy is lucky enough to find somebody with standing in a particular jurisdiction, you'll ask for a do-over, you'll change the program in 2 weeks, and then you'll suggest that the case is moot and we should just move on with our lives. So the fact that so many companies and municipalities in post-2020, at this point in our society, thought that they could implement programs like that on their face are expressly set aside for members of particular demographic groups, does not vest me with a lot of confidence that these more nuanced deployment of these terms and these criteria within companies or within universities or within governments will be heeded and will be observed.
I love it that we've gotten to the point where large law firms have to hire other large law firms to audit their DEI programs.
Just so long as we're the ones being hired.
And paid.
I have to say that, the suggestion of Patrick that, there are only, I've spent almost all of my career, the portion of my career that I've been in private practice, defending corporations in litigation. Not just in race cases, or actually not really ever in race cases, but in antitrust cases and consumer cases and all sorts of things. The notion that our legal system has provided a dearth of plaintiffs' lawyers who are willing to take cases on is, this week I've been hired in 3 different class action cases by a company for cases brought by a dozen different plaintiffs' law firms. So while Consovoy McCarthy is the first among equals, there are more equals than I can name. One of the things, Erin mentioned a point, I think, I see that we have a lineup, and I'll stop.
Yeah, we'll start taking questions in a moment.
Or maybe, Judge, it was you who asked the question about, directors, and is there, is it stereotyping to think that if you want to have a woman on your board of directors, that's stereotyping. I have been giving some thought to this issue of directors and the interest in companies to diversify what, at least historically have been pretty non-diverse boards of directors. And I don't mean non-diverse solely in terms of race or demography or gender, but in terms of perspectives. it's entirely, to my mind, it's good business strategy to want to have leadership, including outside directors, that will bring to decisions a diversity of perspectives and experiences. Whether you could say, well, the next 2 directors are going to be women, or the next 2 directors are going to be African American, is, I think, a different question. It is true that Title VII only covers employees, and directors are not employees under the law. But, I think the advice that I've given is, and I think this is not only good business sense, but good legal advice, is that you cannot, with directors as with employees, you can't make a demographic characteristic the decisional point. Now, Patrick's point that we all know that, people think in terms of, because of the way our society is constituted, and as I said at the outset, we have American society is now bewilderingly diverse, and yet very, very conscious, maybe as conscious as any country in the world, conscious of race and demography. And so if we have to come up with a system in which people don't do what they're inclined to do as human beings, which is be conscious of differences, this is mission impossible. I mean, we're dealing with a world in which we're talking about human beings, and the responsibility of corporations and governments is to acknowledge the diversity, acknowledge the current preoccupation with these distinctions, and find programs that channel that into something productive.
I would have thought that was the point of the Civil Rights Act, to rise above what human beings are otherwise inclined to do.
All right, let's take some questions from the audience. Could you identify yourself before you ask a question, and keep it short, no speeches. Give me a question with a question mark, as one of our other moderators said. Let's start here.
Kai Alberg from Washington State. Start my question with a quick practical example, ask what the panel thinks of it. At a conference last year, the HR officer of a private company called Virgin Orbit stated that she was implementing diversity both racially and with sexual preference at each work team, not just company-wide. When asked by somebody from the audience what she would say to a white male who could not get promoted at that company, she said, "You haven't shed your white privilege yet, I won't even talk to you." Company filed for bankruptcy less than a year later. Everybody was laid off, including this lady. But the question is, in the absence of any government involvement or government contracts, is there a cause of action for an employee who either cannot get hired or cannot get promoted if he does not fall in one of the favored classes that are being sought?
Certainly.
That's easy.
Yeah, yes.
Yes.
Title VII.
What could the cause of action be?
I hope to stump you.
Would be race discrimination. I'm sorry, but you're white and you haven't abandoned your white privilege, so you're not eligible for this job.
That one of the easy cases?
I hope to stump you more. Tammy McCutcheon, I'm with the Labor and Employment Practice Group, former management side employment lawyer, former senior DOL official, former in-house counsel who was a government contractor and rewrote affirmative action plans. So Patrick, here's your next lawsuit. The regulations under Executive Order 11246 require government contractors, of which there are many, to do an analysis of their hiring versus available applicants in using census data, and if your hiring departs by 2% from the available applicants, you are in danger of losing your government contract. Now, DOL says no quotas, but you can imagine when there's a government contracted issue, are quotas. All of the panel, does this survive SSFA?
I would suggest it shouldn't. Seth might disagree.
Well, I'm not sure.
We probably don't have enough facts to give you
Yeah.
actually legal advice, of course.
I mean, if the government is basically saying you are going to suffer adverse contracting consequences if your hiring diverges by more than 2% from the available demographic from which you are hiring. To me, that's easy, which is the government, they can't do that. On the other hand, if the government says, look, government contracts are a privilege, not a right, and we aim as a government to have a society in which, by entirely lawful means, demographic characteristics don't become ipso facto, one way or the other, advantages or disadvantages, or credentials or non-credentials, and we're requesting this information for that purpose to keep you conscious of that, that's not an actionable, but I don't know what this executive order said either before or after you improved it.
The executive order talks about affirmative action but doesn't define it. The regulations define it as you cannot have a statistical disparity between your hiring and the census data on available applicants.
Well, that's stupid. There are all sorts of reasons why.
It's been that way since 1965.
So, as Patrick is well familiar, count one of SFFA's complaint against Harvard, and what constituted probably 70% of the evidence at trial was a claim that Harvard was intentionally discriminating in admissions against self-identified Asian American applicants. A claim that lost in the district court, the Court of Appeals, and the Supreme Court. But the fact of the matter, it was not an available defense to Harvard to say, oh, well, Asian Americans make up 6% of the U.S. population, but 33% of the matriculating Harvard classes, what do you mean? You can still have discrimination, even though there's a statistical disparity. Everybody understands that. And so the way that you've described this executive order seems odd, to be charitable.
Take a question over here.
Frank Seibert from Chicago, and it's a follow-up question to Tammy's question. Please comment on the continued viability of 11246 in light of the decision from the Supreme Court.
No, I do agree with Seth that if you're going to tie liability or the loss of a contract, some kind of penalty under a government program, to the failure to hit a particular target, even if there's a margin of error of 2%, I don't think it's viable. I mean, that's my answer to that question. I frankly wouldn't have thought it was viable before SFFA for the reason I said at the very beginning of this.
But are the mandates that we have affirmative action programs just because we're government contractors? Is that still viable?
Again, the devil's in the details. Some aspects of a quote-unquote affirmative action program may well do it. If it's described exclusively as it was by the prior panelist, I would say no.
Thank you.
Over here.
Francis Menton, I'm the Manhattan Contrarian. Also, my perspective on this comes from 40 years with a large law firm, Wilkie Farr. So I think all the panelists have agreed that making race the explicit criterion for hiring is illegal, but isn't failure to make race an explicit criterion for hiring even more illegal? And isn't really that the substance of the problem? So my perspective from a law firm, if we did not aggressively do affirmative action and go beyond that and explicitly hire minorities with lower grades, lower test scores, etc., if we did not clearly do that, we would not have one single black associate. No law firm can survive that. You get complaints from the government. You get complaints from private plaintiffs. Any law, and you think you can defend that on the ground that, hey, we just applied the same criteria to everybody and made offers on the exact same basis. Well, the other firms are all aggressively recruiting. You're not going to get one single one, and you can't survive it.
Come to a question.
Am I right or am I wrong?
Well, I think you've invoked large law firms, and so I think this question really falls in the first instance to Erin, who also seems to have a particular perspective about large law firms, having been an emigre from a large law firm and now the named partner in a soon-to-be large law firm.
Erin, comment?
Look, I mean, I think that the comment/question kind of reflects part of the problem. I mean, the perception that you could never have any diversity in a law firm if you don't apply a different set of standards to people of a particular race, I don't think it's true. I mean, I don't, may the numbers not be where law firms want them to be? That might be true. But I think there's a vast gulf between saying, the numbers might not be where we want them to be, and saying there'll never be anybody who's in the firm that has a different perspective. And if that were really true, I think what the court's perspective on this is there's a broader problem then that needs to be fixed. We don't kind of have the Band-Aid solution of, okay, we'll have one set of criteria for some applicants and one set of criteria for another. And if you really had a firm that came forward and said, for us to make this decision would require us to apply completely different criteria, which would violate Title VII. I mean, I don't think a court's going to hold that it's a Title VII violation to not engage in a Title VII violation to fix something that was not intentional discrimination on the firm's part in the first place.
So I would just add that, having spent half of my professional career in a very small law firm and now half of my private practice career, half in a boutique firm and half in a large firm, I'm pretty conscious of hiring and recruitment and what's going on. And one of the things I think that successful law firms, large or small, have found is that how well you did on your standardized test scores and what your grade point average is. When we're talking about being a success in private practice, they don't correlate very well at all. And the question of what law firms are looking for when we go recruiting is somebody who is, seems to have the potential and a broad range of skills, interpersonal and otherwise, that could make them effective lawyers and trusted advisors to clients. And it's remarkable how poorly that correlates with grades and test scores. And that's what we found both in my small law firm and my large law firm. We're not looking at, if you look at the people at Wilmer who become partners versus the people who we hire coming in, there's no correlation whatsoever to where you went to law school and where you finished in your class. We try to hire people who went to good law schools and had good legal training and did well in their classes. But just like universities, with the exception of a place like Caltech, which is, given its mission, is looking for the highest achievers with respect to in the STEM disciplines, universities are also not evaluating which applicants are most likely to be successful graduates and members of society based only on, one or two particular metrics. And that's how it's done.
There's some other questions that I think we want to get to. I'll just briefly say that one of the points that I think the question gets to that it's very much worth reconsidering is the wisdom of disparate impact liability, which is what I gather is really the concern and the rock and the hard place that you're stuck by there. And so if you read, especially Justice Scalia's concurrence in Ricci talking about the Equal Protection Clause, I think there are harbingers for future legal disputes down the line on that point.
Next question.
Hi, Andrea Lucas. I'm a commissioner at the EEOC, so obviously I have a vested interest in this discussion. But I wanted to ask Mr. Waxman, I wanted to push back a little bit on your discussion that it's fine for companies to generally promote diversity simply based on the idea that it's good for clients or customer preference or things like that. The EEOC has long had a position that, and Title VII has long had the position that customer preference and client preference does not support racial classifications. So I just wanted to flip it on the head for you. If all of the social science said that homogeny was good for companies, would you feel comfortable with your clients having general statements saying, well, if this person understands majority culture or the general white culture, or they're going to sell better to our homogenous clients, would you feel as comfortable that not serving as evidence that there might be intent of discrimination, even if there was no racial classification?
Can I just interrupt you for 1 second, because at like 4 points during your question, the door opened and we have apparently 100,000 people screaming right outside the door. So I don't know about others in the room, but I didn't hear enough of your question. Could you just could somebody bar the door for a second and give me what your question
Note
is?
to Federalist Society.
My question is, why is a general customer or client or societal preference for diversity a legally relevant question, right? If you're selling to exclusively white clients, we would never say that was justification for only hiring white salesmen or white lawyers, right? Why is all the social science that you're pointing to, or customer or investor preference or any of those things, legally relevant to a push for diversity?
Well, the question, I think, is not whether it's legally relevant. It is
or permissible.
Why
is it permissible?
The question of legal permissibility is you cannot use race qua race as an employment factor, period. Whether you're selling to all white people, all black people, or all people whose names begin with vowels. The question is whether, as a business, given the nature of your customer base and the nature of the kind of internal work culture you want to build, whether diversity and a feeling of inclusion is consistent with your mission. You are not the government, you are a private entity that's entitled to have and express its own values so long as they don't violate the law. And so taking into account that you are let's say a consumer products company or a consumer services company that is serving a diverse population, and therefore it would be good to have people in the company, without engaging in stereotyping, have a sufficiently diverse understanding of the world in which they're selling into, is entirely fine as long as you don't cross the prohibited line.
Let's take a question here and then I'll come back to you.
Yeah, a question about the decision itself, SFFA. The Supreme Court the majority took the pains to drop a footnote explicitly stating that the holding did not extend to the military academies. While not explicit, the implication is because of the correlation with employment that those institutions have. And of course, Justice Gorsuch's concurrence, joined I think, if I remember, by Justice Thomas only, was a concurrence. What's the confidence level that the current majority of the court actually would extend the reasoning of the case to employment, private employment?
Patrick, he mentioned the military academies, so you have to answer this.
The military academy provision in Students for Fair Admissions is now subject to an actual test in 2 actions that our firm has filed against West Point and Annapolis. So at least, although I understand your question to be about extension to private employers. Well, my view is it's not necessary to extend it to private employers because universities were always the exception, not the rule for at least this diversity interest justification, which I guess is sort of what the point of my opening remarks are. I do think, and I can confirm, in litigation, it is being cited by courts as relevant information for setting forth the standard, at least for governmental decision-making, but also in areas such as 1981 litigation. So I do think it is going to have relevance. I think the principles that it relies upon are drawn from other aspects of law, including in the employment context. So I don't think it's irrelevant.
Yeah, no, I mean, that seems right. I think the interesting question, I think it's pretty clear, once the court says we're interpreting Title VI as consistent with the Constitution, you're going to get to the same place Title VII, and the law already was what it was. I think there's some interesting questions more about 1981. It's just things haven't been answered as much in the 1981 context, and the statute is actually worded quite differently. I mean, it's quite different from the modern civil rights laws because it specifically applies to say that you have the same rights as whites. And so it's just like, there's just aspects of it because it's a statute from 100 years earlier that are different and raise some different arguments that haven't actually been. I mean, I think that's more of the open question in these cases has been, what exactly, does all of this apply the same way in the 1981 context, which matters a lot for both it can arise in the employment context itself, but for all the things that are not covered by Title VII.
Right, last question.
I was hoping to ask about, it's Christmas season almost, and so all the holiday catalogs are arriving, and I've noticed a lot of companies are particularly choosing and advertising and carrying products by companies owned by certain demographic groups. And obviously that's not employment based. So I wonder about these other sorts of quotas outside of Title VII. I think, as the panel's made clear, Title VII is pretty clear. But what about other preferences? I think Uber offered some preferences for products carried on its platform based on the race of the owner of the company, for example. So I'm wondering how it looks outside Title VII for companies making decisions based on race and gender.
I'll just briefly say it can be very dependent on what the particular state that this is originating in. There are some state laws that are more protective and more expansive than others. California in particular has a relatively expansive prohibition on race and other demographic factors being used in business transactions. But it does depend on those cases. I think we all agree there is some level of advertising or recruiting, even if it is intended to expand the audience for a product or to increase the recruiting base for a university or an employment, that will probably fall well on the safe side of what you can do. But the devil is in the details a lot of times.
And the only thing I would add is, there is a level at which that you start to bump up against some First Amendment interests of the private company, and I think all that gets a little bit trickier when you get further away from traditional employment decisions or very traditional contracting.
I'm sorry, I don't think we have time for a last question, so would you help me thank our excellent panel? I have two public service announcements. One, Union Station is out, Capitol Hill, Washington Hilton. And also there's a very fine historical document exhibit upstairs by the Remnant Trust, and there's a copy of a 1350 Magna Carta. So go check that out when you have a chance during a break. Thank you. All right. Thanks for joining us again.